Good morning, everyone. Welcome to our webinar. This is Sharon Francis. I am the um, business advisor for the Columbus Urban League Minority Business Assistance Center. We are so glad to have you with us today. And on behalf of our director, Jesse Mark, and also President Stephanie Hightower of the Columbus Urban League, we want to welcome you to this time with us today. We have with us Paul Bryson, who's from the Legal Aid Society of Columbus, who is going to be sharing with us about commercial leases, how to secure your storefront, and you as business owners that may be even considering um, uh, opening a separate facility for your business, you need to know and understand the leasing terms that would be pertinent for that transaction. So we want to give you the information that you need to know and put you in touch with the resources, and assistance perhaps that you may need. So I am going to yield the floor to Paul. But before I do, I want to tell you just a little bit about him. He's a staff attorney on the Community Economic Development Team at the Legal Aid Society of Columbus, where he focuses on representing small businesses and nonprofit organizations. He's a lifelong resident of Columbus and earned his JD degree from the Capital University Law School. And before joining Legal Aid, he actively practiced family law, criminal defense, and business law in private practice. And I like this part. In his free time, he enjoys being a husband, father, cat dad, medieval enthusiast, and a font, did I say that right? Of occasionally useful trivia and dad jokes. So he is an expert, and so he might even share one with us today. But again, I'm going to yield the floor to Paul, and thank you, Paul, for joining us.
Well, thank you so much for having me. It's often harder to avoid my dad jokes than end up getting them. So I'm sure that they'll make an appearance today. Um, Thanks everyone for coming and being with us. I love to do this presentation because I think it takes some of the mystery out of one of the one of the hardest things to do as a new business owner. I think most of us have dealt with uh, renting property in some way, usually in a residential setting, and we get very used to that idea. Um, but commercial renting works so much differently that I feel like it can really end up putting people at a disadvantage when they don't know how that works and how it's more flexible and what you can accomplish with it. So I'm always happy to come and do presentations. I love being able to come do things here with the Urban League. So thanks for having me again. I'm going to talk about a few things. These terms are going to come up a lot, so you'll hear them. Lessee, lessor is just the renter and the landlord. I'm going to try to use landlord and tenant more often because I don't like those or terms. They end up confusing folks really easily, including me sometimes. The term, when we talk about it, is usually going to mean the term of the agreement. So 1 year, 5 years, 10 years, whatever you're dealing with. Usage is going to be dealing with the allowable uses of the property. So, if you're renting a place to live, the allowable use is it's a place to live. For business, it's going to be a lot more flexible. And it may have some restrictions you're not used to seeing. So a lot of times it'll be kind of you've got to worry about whether you're dealing with any kind of hazardous materials. So if you've got a cleaning company, or I guess some types of hair products maybe might end up being considered hazardous materials. So if you have a business that deals with chemicals, that's something you'd want to look at in your lease to make sure you're not breaking it by storing the kind of things you need to have. I know that we're going to be having marijuana-related businesses here in Ohio as time goes on. One of the things that has been important in other jurisdictions has been making sure, since it's still illegal federally, but some different uses are become legal in the state. If someone does have a business that's dealing with products like that, they're going to want to make sure that the acceptable uses, because there'll usually be no use for illegal purposes, making sure you get that defined. If your business is in that kind of interesting legal ground, I'll call it, as everybody's trying to figure that out across the nation. Mandatory arbitration is something you see in a lot of commercial leases. In general, a lot of lawyers, especially in my position, are suspicious of arbitration because it takes you out of the normal court system and puts you in a place where you kind of hire private judges. And there's always the chance that the people who deal with them more often, who are going to be usually the larger players, who are going to be, the companies that are requiring the arbitration, things like that, they're repeat business. So there are a lot of studies that show maybe there's some bias toward them in those settings. So I like to try to avoid arbitration. That said, arbitration isn't always the worst thing in the world. So if I were looking to, if that were going to be a deal breaker, I don't know that I would necessarily want to negotiate that out in a commercial lease, but it's always something to watch for. And choice of law is probably something that you've not really thought about before. But when you make a contract, and a lease is just another kind of contract, you can end up dictating in that contract what law is going to apply, the law of what state. So I always try to make sure that it's the law of Ohio that applies. And that's because for my clients, I'm only admitted to practice in Ohio. The laws of other states are not things that I necessarily know very well. And I don't know what kind of hidden kind of traps or wrinkles are in those laws. So if there's a choice of law provision, I always want to say that Ohio law applies. And sometimes, especially with multi-state landlords, you'll see that they say, we want Nevada or North Carolina or, the law of whatever other state to apply. And that's a legal provision. I mean, you can do that. You just may decide that you don't want to. So something to look out for. Price is always super important. You're in business, you got to figure out what your expenses are to figure out how you're going to make money. And what we're used to in residential terms is it's going to be this much per month. And that's it. It's going to be a 3-bedroom for, I don't know, my prices are out of date, but 3-bedroom for $1,500 a month. That's probably low in current market, unfortunately, but let's say it's that. In commercial terms, there are going to be lots more different ways to do that. So sometimes it'll just be a straight price per square foot, which is what you will often see as kind of the default normal breakdown. So $12.50 a square foot, something like that. You'll want to look at what kind of square foot measurement they're using. They're generally going to use the Building Owners and Managers Association rules for measuring square feet. There's nothing wrong with those. But then you need to know whether they're using usable square feet, which is going to be the space you're actually going to be in, and get a look at that space to see how usable that really is for you. Or whether they're using rentable square feet, which is that usable square feet plus any common areas. So lobbies, waiting rooms, if you've got shared ones of those, or sidewalk parking lots, things like that. That way you know what it is you're actually dealing with. One thing that can be really interesting in these is sometimes you can have, and actually a lot of times you'll have a situation where you'll be able to get the price per square foot set at different levels for different times in your business. So the best example is, say it's a building, you're going to be getting established, you're a relatively new business, and it's a 5-year lease. You might see that you might arrange for the rental price to scale up over those first 3 years, because as you're getting established, as people are getting used to where your location is, all of those things, they'll recognize that there won't be as much ability to pay rent there. So you'll pay more in that, third, fourth, fifth year than you do in years 1 and 2, for example. And that's something that you would not see in residential, that becomes available in commercial. Another way that you can kind of do that situation is, especially for scale up kind of purposes, is you might be able to do something that's like a price per square foot plus some portion of gross receipts. So a good example would be, maybe instead of $15 a square foot, it ends up being something more like $14.59 a square foot, which saves you on base rent. But then you say, and 2% of gross receipts over 75,000. So you earn 100,000 that year, and you can see the calculation there where it ends up being 1,500 a month. That can be a great way, if you can get a landlord to go for it, where they get paid more the more successful you are, and you secure yourself a floor, where okay, this is going to be my expenses for sure, and then if I'm really successful, and more able to pay some higher expenses, then I know this one will go up. And it creates a way where you're kind of riding along together. And this actually is fairly common. I've seen it several times. You see it a lot in like strip mall kind of situations. There will usually be some provision that talks about additional rent. So there'll be this base rent and then additional rent. That additional rent, sometimes you'll hear a lot of people talk about it as CAM. And there are lots of ways you can do that. A lot of times it is going to be somewhere between the landlord is covering all expenses, you pay a flat rent and that's it, and you pay base rent plus some portion of every expense. It'll usually be somewhere in between that spectrum. This can be interesting because the way you negotiate it for your business might make a big difference. And I'll give you an example here. A lot of times we talk about these as, net, double net, triple net. And you can see the spectrum here, where as you move toward triple net, you've got the tenant fronting more of these costs, or paying out more of these costs. The reason that ends up working is if they are expenses that the tenant is able to have more control over, like the use of utilities, or the types of repairs that will end up needing to be done by the landlord, the tenant can save some money on base rent by agreeing that some of these expenses will be their responsibility. Whereas if you want the ultimate in security of, I know exactly what I'm going to be paying, and that's the way that you want to make sure you have it, paying that higher base rent for more on that full service kind of scale would be the thing you'd want to look at. So I like this because it tells you, excuse me, it tells you the kind of flexibility you have in commercial leasing that we just never see in residential leasing. I'll make sure that I send my presentation so that you can see some of these kinds of things. What I like these kinds of slides for is that you can see what a provision like this may look like. So this triple net provision, you can see there's this long list of things that the tenant ends up reimbursing the landlord for, That usually works as we estimated at this much, and at the end of the year there is a true up where you find out what they actually were, and you may get a credit, or you may end up owing more. So paying attention to what's in that list, negotiating along that list, all of those things ends up becoming important. When it comes to repairs, as a tenant, the landlord is going to be doing all the repairs, hopefully. I think we've all heard of landlords that aren't doing those repairs, but generally they're the one responsible for them. In a commercial lease, that's not going to be the default. The default is going to be that whatever the lease says about somebody being responsible for repairs is how it works. So you will want to make sure you know the condition, you have a good idea of what kind of repairs are likely, and making sure you know at the front whether you're going to be on the hook for them or the landlord is. Now, you can be able to potentially press the price lower by taking on those repairs yourself, but you've got to make sure first that you can actually handle those repairs, and that the cost of them won't break your business, and that the kind of shutdown or interruption of business that you'll have from having to shift your attention to focusing on those repairs instead of focusing on running your business won't end up costing you a bunch of revenue and cheating yourself out of the opportunity to be making money with your business. But make sure that you get this figured out. I'm going to show you a potential provision here that I've seen sometimes. Here you see the tenant has to make all necessary repairs, except for major mechanical systems or the roof. So those are going to be things like the heating, ventilation, air conditioning, plumbing, that kind of thing. So this is one where the tenant has got to be pretty secure that they're going to be able to pay for and hire the right people to do that. This is a great provision for somebody who wants to keep their costs low because they know lots of people in those repair kinds of things and can get deals, or they've got those skills themselves. This would probably be a bad provision for, when I was in private practice, this would have been a terrible provision for me. I'm a decent lawyer, but I'm not great at these kind of repair things. And the money I would have lost by taking time to do the repairs myself instead of practicing law, which was what I made money doing, would have been made that a terrible trade-off. But for other people, or depending on staffing, depending on your industry, that may be something that you negotiate out. And I've seen all kinds of variations on these in all kinds of ways. I always like to tell people about this ameliorative waste situation because it's weird. It's kind of dumb in modern terms. So this comes to us, all the law ends up coming to us from, Old English things. And so the kind of cases that this concept comes to us out of is, somebody leases a farm from some lord, and they plant a bunch of apple trees. They plant this orchard, and then the end of the lease 20 years later, the landlord gets the farm back and says, "What did you do to all of my cow pasture I had? It's full of apple trees and I can't do anything with it." In an objective sense, that orchard is probably worth more than the equivalent amount of pasture land, but it is still waste if the landlord didn't want that permanent change to be made to their property. So the short version of this is, if you're going to make improvements, you're going to turn an area into maybe medical space where you're putting in lots of cabinets, examination beds, massage space, something like that. You want to make sure that you get permission to make those kinds of permanent changes. or semi-permanent changes, because otherwise when you move out, you can end up with a bill for restoring it to where it is. That will be something that will be in writing. If you're doing this deal well, you'll have it in writing exactly who is doing what to make improvements. If you're putting walls in, moving walls, adding plumbing, removing plumbing, cabinetry, any of that kind of stuff, permanent shelving. If you're adding value, make sure you get a discount on the rent that way. So if you're taking an empty space and making it a usable space, in a way where the way you make it a usable space is going to get left behind, so you're installing wall shelving that another establishment can come in after you and use, that you're not going to be able to take with you. You're making a change to that property that makes it more valuable, makes it easier to rent in the future. This is especially true for food businesses. You're putting in ranges and hoods and refrigeration and all of those other things that other food businesses need. You're making it easier for the landlord to rent it to the next person, because some of that stuff is going to be too expensive for you to ever remove when you're done with that space. So you need to be getting compensation for that. Or if you're going to be paying them to do that, then you want to make sure it's done to your kinds of specifications. Some of this comes down to a legal concept called fixtures, which is something you install in property that can't be moved without some serious destruction. So you see that a lot in manufacturing, where there are big machines that you can't really get out of there very easily. I think a great example is, there's a reason that once a place is a restaurant, it tends to stay a restaurant, because a lot of specialized kitchen equipment, whether it's the big range hoods or the refrigeration systems or something, just can't really be moved once it's installed, not without really, busting out some walls or something serious. I always want people to take a look at whether they're going to be able to have the signage they want. And some of that is not necessarily going to be in the lease. The lease may say nothing about signage, but you want to find out what your local rules and regulations say about signage. And I like this picture because it reminds me of a real life example. I had a business that I was representing in Gahanna. There was a place across the street that had this big old-timey sign. This giant sign sits way up in the air. Everybody can see it. But my client could not have a sign like that, not because of the lease, but because after that sign was erected for that other business, the city passed an ordinance restricting signage. So that one got to be there because it was a pre-existing use, but nobody else could have a new one that would go like that. And in fact, if that business tore down their sign for some reason, or it got knocked over in a storm or anything else, they couldn't put it back up. But it's an example of when even looking around wouldn't put you on notice of what it is that you're allowed to do. So I think that's a very instructive kind of example. And sometimes there will be provisions in the lease about what kinds of signage you can have, or whether the landlord needs to approve it or things like that. So especially if you are going to be relying on drive-by or walk-by traffic for your business, instead of people coming to you wherever you are because they know you and want to go there, that signs are vital. There's always going to be common areas in a commercial lease. We don't worry about them too much in residential leases because, the stairway, if it's not in good repair, there's going to be a problem with code and everything else. But in these business leases, You need to make sure that the common areas and the way they're used and the way that they're maintained doesn't hurt your business or cause you some kind of liability. So figuring out how the parking lot is going to be able to be maintained, whether you are responsible for some of that payment, or whether the landlord is responsible for it, how that's going to work, whether there are designated parking spots, because especially in kind of a strip mall situation, especially for food businesses, those designated spots can be absolutely vital for your business. CAM, like we mentioned, is that common area maintenance charge. It's part of that triple net. It's usually going to be that estimate, but you may want to cap it. You may want to see if you can negotiate something like it's $2.50 a square foot as additional rent, but under no circumstance can it exceed $10,000 as just a kind of off the top of the head example. Capital improvements are things like trying to get a brand new roof for a building, or trying to add on to a building. You want to see if, because sometimes those decisions will be completely out of your control. So finding out who is responsible for paying those. And then there may be, excuse me, a fund that everybody in the area pays into for promoting, or a merchants association, or those kinds of things to make sure that you especially would see these in mall concepts, where it's the thing that advertises the entire mall, and does the marketing for that. Now, speaking of neighbors, there are a couple things that you can do and that you'd want to look for to kind of protect your business. My favorite example of this is there is a Subway sandwich place that is right next to a neighborhood pizza joint. And when Subway started doing pizzas, that was what my daughter wanted to have from Subway. And so we went to this Subway, and they had a sign that they weren't selling the pizzas, even though every other Subway was. And I found out that was because the pizza place that had been there for, I don't know, ever, since it was built, had as part of their lease that the landlord would put a restriction in everyone else's lease that they couldn't sell pizza. So that Subway franchise, because of their lease, wasn't allowed to sell the pizza that every Subway was selling, because the pizza place had been smart early on, and had gotten that restriction in everyone else's lease. Because of course, if all you sell is one thing, somebody else comes in selling the same thing, you might be in a lot of trouble. So I thought that was super smart. That is an example of one of those competitor clauses here. And I think those are great. A co-tenant clause is a neat one to be able to do too. This was part of why you saw places like Eastland Mall and Northland Mall kind of deteriorate and lose shops so quickly when they lost the big anchor stores. Because the leases would say something like, if at any time the anchor stores, the Sears, the JCPenney's, Lazarus, is no longer at this location, then that gives me a chance to get out of my lease. And part of that is because I think we all know businesses where they aren't necessarily the big destination, but they get a lot of, oh, while I'm here, I should go there, kind of thing. And a lot of the smaller mall stores relied on that. You see that in strip malls sometimes too. They get the Kroger or the Giant Eagle. or the Walmart, and that brings in the drive-by business that gets people to go to the Mexican restaurant or the store that sells pens, or any of those more specialty, less well-known kind of shops. And here's a good example of one of those co-tenant clauses. This is not specific to an anchor store, but it is about total occupancy. So this one is, if we go below 85% total occupancy for this location for more than 6 months, I get to pay less rent until we've gotten back to that 85% occupancy. And this is really one of those, we all are together in this kind of clause. And then here's an example of that exclusive use, that kind of monopoly kind of clause, where, hey, nobody else has that ability to sell pizza. Nobody else has been told they're the only people who can sell pizza. In the future, you won't give anybody else exclusive rights to sell pizza. We're going to be the people that can do that, and we're going to be protected from you making it so that we can't do business. Which for that pizza place, I think was huge, because there were people like my daughter that would come in and order pizza at the Subway, because that's what kids do. They go to the places that they've heard of, and maybe not the place that had been there for a long time. I'm a lawyer, not an insurance person, but I have to tell you, insurance is absolutely vital to your business. If you're running a home-based business now, what you want to look at is whether you have a rider that covers operating a business in your home, because a typical renter's policy or homeowner's policy is not going to cover any kind of commercial activity. So, for example, you have a client or a customer come to your home for something. They trip on the front porch and bust their face, break their nose, orbital socket, all of those things. Normally, that's not a huge issue. If they sue you, your homeowner's insurance or renter's insurance is going to step in, protect you, and cover that. But if they were there for business, there's probably going to be an exclusion in your policy that says that your insurance company doesn't have to protect you or cover you. And then it's entirely you on the hook. Very similar with auto insurance. Your auto insurance is generally going to say that it only covers you when you're using your car for your personal or family use, not for your business use. So that's going to be that's a nasty surprise when you think you're covered and you find out you're not. The good thing is that's usually a rider that you can get from your regular insurance agent. Might cost you an extra $20 a month or something like that. Won't be a huge extra cost, but is a lot of extra protection. So it's very useful. But when it comes to getting a commercial space, sometimes there'll be a minimum in the lease. It'll say, if you're going to lease this space, you're required to have a policy that covers up to $1 million per claimant and $2 million per event. That kind of thing is very common, or maybe 500,000 and 1 million kind of things. If you want more than that can always be something you do, but a lot of times they're going to have that be a minimum. And I've seen lower minimums. Some of it depends on what kind of business you're in. You may want to look at business interruption insurance. This saved a lot of people's bacon during the pandemic because there was something that kept them from being able to do business, and they had insurance that covered that. Now, insurance being what it is, I will tell you that there were lots of people who had to sue their insurance companies about whether their business interruption insurance would cover the business interruptions from COVID. But they at least had a shot instead of just being completely out of luck. And if you do improvements and things on the area, you're going to want to make sure those are insured. And if you've got workers, you've got to have workers' compensation coverage, whether it's through the state or whether it's private coverage. Now, there are some kind of special leasing topics that I want to make sure I cover because they're a lot more common than they used to be. So you see a lot of these booth leases now, especially when it comes to hair, nails, those kinds of services, where it'll be a short-term lease. Sometimes your rent will be a percentage of your sales, or something like that. You may have to follow more of their rules. They may have like a conduct code. I know, for example, Salon Lofts is a place that I've known some people that have had booths, and they had some pretty strict restrictions on like what kind of decorations and signage and things that a stylist could have in their booth, even though they were independent, not working for Salon Lofts. They were able to exercise that kind of control to have a uniform presentation. So those kinds of things. So those leases will not have as many of the kind of like repair clauses or things like that, but it'll be important to look at what kind of requirements they're going to put on you. And pop-ups have been huge. Pop-ups have been absolutely huge. They're a great way to test your service model, kind of get some buzz, see if there is enough kind of demand for what you have, all of those things. These could be as short tenancies as hours, could be a 12-hour tenancy. If it's, an absolute pop-up. There'll usually be a flat rent for these because, of course, there's not going to be repairs and things that need done. It'll be a bring what you have and take it when you go kind of model. You will want to make sure that if you need permits for what you're doing, that you get those. You may want to make sure that you've got an option to cancel. If your social media marketing is telling you that when this pop-up opens, you're not going to get the demand you need to pay for it, you're going to want to be able to have that option to cancel. And you're going to want to make sure that it happens when it works for your business to happen. You do not want to have a situation where they've got a different pop-up every week and you get no guarantee of what will happen if the previous one hasn't gotten everything out of the way so that you can be there now. You want to make sure that you have built into the contract some way that you get compensated for that. I can't say enough times, everything in commercial leases absolutely need to have it in writing. Any change, any addition, any modification, anything that you want from the negotiations, everything, and signed by the landlord. That is because we have a law called the Statute of Frauds. It doesn't actually have anything to do with fraud, but what it is a law that says certain contracts have to be in writing, and if they're not in writing and signed by the person you want to hold responsible for them, that you don't have a contract, and you can't hold people responsible for them. So you really want to make sure that you've got that in that writing, because otherwise the judge may have to tell you you're just out of luck, and that is a nasty surprise. And as you're kind of going through and negotiating this, setting this up, you want to prepare for the different, planning is everything. So plan, okay, what am I going to need to do if I am going to succeed exactly as much as I ought to? Am I going to need more space here? Am I going to need to get out of here and go somewhere else? Or is this going to become the first of many locations? Each of those has a different kind of plan to them, and different kinds of needs. Maybe you need to be able to get an early termination. They may even be worth paying for at the time you exercise it, if you do that well. Maybe you get a right of first refusal on a neighboring spot if a neighboring spot becomes vacant, that kind of thing. Plan for problems. Get some kind of protection in the contract for landlord doesn't make repairs. It's okay for you to make repairs and discount your rent that way. that'd be a great clause to have. It does a couple things. It encourages the landlord to make repairs, because often they're hiring those people more often than you are, so they get a better price, and they don't want to have to pay the price that you're going to pay if you go out and find a contractor to do it. So it makes it more likely that they're going to actually do them, and it gives you protection if you end up having to do them, rather than having to litigate that issue down the road. And plan for renewal. If you I had a lease recently that I helped a nonprofit negotiate, where they were only going to be able to get some assistance money in getting this lease set up if they had an option to be able to renew for up to 20 years. So we were able to negotiate, a series of renewals with a very small price increase over time, because we had a very friendly landlord in that case, and we were able to get the option for renewing for 20 years, and some protection against if this place really takes off, and there are lots of things we can do there. I'm going to check the chat here because I see that there have been some questions. Oh, no, those are just people telling us about their businesses, and I see a couple familiar names. So hi to those of you I met before, and it's nice to see you again. If things go badly and you're going to end up being evicted, I want you to know, residential tenants have all kinds of rights and all kinds of protections. Commercial tenants don't. Commercial tenants do not. It's bad enough to be on the verge of eviction when you're a residential tenant, but folks like our housing attorneys are good at dealing with that, because at least there's a little bit of law on your side. In a commercial sense, unless the lease gives you a protection, you got nothing. So it may be, you get that eviction notice and you have got to be out, or they can clear you out. So being able to protect yourself there is important. Know what the other triggers are. There's usually things that are going to be a default other than just non-payment. So non-payment's always a big one. But the other things will be, you're doing some illegal activities, the place has been condemned, you are doing business in some way that disrupts everybody else's ability to do business. So know what those things are. Make sure that they're not part of your business model. That'd be another time that it's important for those marijuana-based businesses, or I see some fitness clubs go do demonstrations in the parking lot as part of their marketing. I think that's great marketing. It does make people stop and stare and be curious, but making sure that if one of the other tenants complains about that it doesn't cause you a problem is important. Cure periods are great. Cure periods are basically, a 15, if you don't fix this in 15 days, if you don't fix this in 30 days, then they can look at evicting. But they have to tell you there's a problem and give you time to fix it first. I love cure periods because it lets you make mistakes without getting punished. And that's huge, because you got to try different things as a business and try things that weren't necessarily in the plan sometimes. And you want to make sure your lease has protection for if there's going to be a new owner for the whole building. Usually it'll be there. Usually it'll be more like you have to accept a new owner with the same lease terms if they get bought out. But it's good to look and make sure it's in there. This part is something I hate. I think that they ought to be found to be unethical for lawyers to be involved in them. But we've had them for a long time, and I'm probably never going to win that policy argument. Confession of judgment or a cognovit note says it'll be a separate part of the contract, usually at the very end, and it says if I default, you as the landlord can go hire an attorney to represent me that says that's able to sign and say, yes, I'm guilty. I don't have any defenses. I am just, you can just have a judgment against me right now. I think it's one of the weirdest things in the entire world. The idea that there can be some lawyer who represents you that you don't even know exists and that you've never met and has never talked to you, and that they can sign away all your rights is super strange. But that's what a cognovit or confession of judgment clause does. A lot of times these will be with a personal guarantee that says that not just your business, but you are personally on the hook. And then you've got a judgment against you, and they can go into garnishment or levying on property or anything else. And I think that's an absolute nightmare. So, watch out for those. Here's what one of them looks like. Honestly, if there's a confession of judgment, a lot of times that is a we negotiate this out or I walk away and find somewhere else kind of a provision, because it's just they're that nasty. You find out there's a problem when somebody puts a lock on your door and has an auctioneer trying to sell your property, kind of situation. And I think that they're just terrible. I think I did manage to successfully leave a little bit of time for questions. We do represent small businesses and nonprofits, Legal Aid Society. So you can call the Legal Aid Society intake line and you'll get to me, or you can contact me. As I said, I'll make sure these get out to people. I'd love to talk with you. We do have some intake criteria. So if we can't represent you, I will point you to some people, and it'll be better than looking in the phone book. But I would love to talk to you anyway and get that figured out. And then I just have this as a kind of a checklist for you that'll be at the end of the slides when you've got them there. Oh yeah, there's another couple familiar names. Wonderful. Any kind of questions or anything that I could answer, or anything people would like me to talk about?
I'm loving that dad joke right there. That was great. Ah, thank
And both of
you.
my cats are right on my desk. You've seen Teeny Tiny a little bit, but Itty Bitty has just been laying over here. So.
I love it. I love it. Listen, I have to apologize because I've actually had been kind of multitasking, got a fire I'm trying to put out, but this is great information. I am going to be reviewing this recording myself, because this is, there's a lot of nuances, to leasing spaces. And I'm glad that everybody that has been on the call today, um, has been able to hopefully get some good information out of this, because this is fantastic. Um, Particularly when you're talking about sharing space, like the booth rents. I don't know if we have any people here that are involved in hair care and, and all of that. And then the other piece that I thought was significant was when we were talking about even the pop-up shops. Yeah, because a lot of people don't even think about, that's actually leasing space, and that you do have rights, and should have your expectations in writing, in terms of what they're supposed to, how that should, function, and dealing with, competitors and co-anchors. Good information, good information. Yes, are there any other questions for Paul? Or any other, maybe something that he talked about you want a little bit to know a little bit more in detail? Okay, great.
That in writing part is so important. Back when I was in law school,
Hmm.
as a law student, you can get kicked out of law school and never end up becoming an attorney if you give people legal advice. We're pretty serious about that. And
Uh-huh.
my mom told me that she was looking at renting a place from somebody, and she said, "This guy said, he's real friendly. Said we don't even need a lease." And I said, "Look, Mom, I can't give you legal advice. I'm not allowed to.
Mm-hmm.
But think about it this way: um, if you've got something in writing, then you don't have to remember what you've said and what the terms are, because your memories are going to be probably different.
Right.
Instead, you've got something objective that a person outside the two of you can look at and know what you actually agreed to, instead of just what you both think you agreed to. It's that whole thing. There's what you think, what they think, and then what actually happened. The writing gives you what actually happened. So
Mm-hmm.
I am all about having things in writing. I like handshake deals on principle. Like in my personal life, I do a lot of things by handshake.
Mm-hmm.
But when it comes to businesses, I mean, absolutely.
Mm-hmm.
Um,
Looks like you got somebody is suggesting that they want to know more about pop-up shops.
I think that'd be great. I'd love to put together something a little more in depth about those.
Fantastic, fantastic. Thank you, Shelley, for that comment. Any others? Any other ideas or any thoughts that you think maybe we need to focus on going forward? Okay. All right. Well, if all minds and hearts are clear, again, thank you everybody for joining us today. And thank you, Paul, for this excellent information. And how do people contact you if they need a consultation? Can you give us your.
Absolutely. I just put my direct dial in the chat. That's a great way to get a hold of me. Although I think I just sent that to hosts and panelists instead of everyone, so
Okay.
I'll do that again. Um, I just emailed all the slides to you, Miss Sharon, so that
Okay.
you'll be able to get those to people who registered.
Okay.
And then my email, which is always a great way to reach me, is going to be right here in the chat too. I've got a couple people who work with me on my team here, so
Mm-hmm.
we do have some capacity. I'd love to have a chance to talk with people a little further. A big part of our project is we can only help people who are eligible for our services, so that's generally going to be people with less money. Uh,
Mm-hmm.
and part of our thinking in that is if we can give somebody, $3,000, $5,000 worth of legal services, that is just as good as having 3,000 or 5,000 in the bank to start their business with. So trying to make sure that we're supporting our community that way.
Fantastic. Fantastic. We appreciate that. Well, our next week we will be talking about human resources with Charlene Davis at 11 a.m. And so, any of you that have employees or are considering having employees, you definitely want to attend that webinar as well on the 29th. And again, we just appreciate everybody being here. Um, Paul, thank you again. We will be sending this recording out to everyone who has registered. So you'll have a chance to go back over it. And if you have any questions, you can reach out to him directly. Again, thank you for being with us today. And hopefully, we'll see you next week. Be well.